Hello, neighbor. I'm Robert Burns, and welcome back once again to another edition of Sound Off Louisiana. And I promise to keep myself a little bit better composed for this feature because now I can finally take a break and relax. As I reported on Sunday, I told you we would let you know how things went at the court hearing yesterday involving Burns versus Davis. This all has to do with the letters of counseling/warning, as well as any other documents that Judge Johnson may feel free to release if he's so inclined. But those are the two that I wanted the most. And we held the hearing yesterday, and I was pleased with the way it went, and I'm sure if you talk with opposing counsel, they probably would say they were pleased too. So the bottom line is that we were, and I'm going to go over a little bit of the high points, and then I'll tell you what the final, or not the final outcome, but where I think everything stands. I was asked to go first as, I guess, the plaintiff in this thing, and I said, Your Honor, I'd like to just pick it up where you wanted us to go on May the 23rd. You wanted us to get straight to the point about what we wanted, and if it's okay, I'd like to do that. And he said, certainly. And I said that, well, first of all, I need to move for leave of court to be able to oppose oral arguments on the amicus brief that was filed by the Louisiana State Police Commission at around 2 o'clock on Friday. You all will remember my frustration of basically my weekend was shot because I'm being bombarded with this stuff that, quite frankly, I still don't have the filing that Mr. Farinholt made because it was placed in snail mail. So here we are, the hearing's over, and I still have not gotten that document in the mail. But at any rate, be that as it may, I said, Your Honor, it's a long story as to how we got where we are, and it's not really relevant to go into that. I said, but the bottom line is we now have six sets of documents that have been placed under seal for your review. I said the first is the 137, give or take, redacted pages that I was initially supplied with, and I'm very pleased that they have placed those documents under seal for your review. I would be most appreciative of any document that you deem fit to be released to the public. Obviously, everyone in the room now has an advantage in that they know what, well, not everyone, but this time the attorney, Greg Farinholt, in contrast to the last time where I assumed LSP had provided him with those records, this time they had. And so I said, anyone that you may be inclined to release, I would be more than happy to accept. I said, now the second set is the unredacted documents. And I said, I've been all through those, Your Honor. And I said, if you want to have some material to put you to sleep, that's it. So I would encourage you to just go ahead and forget number two. I said, however, I will point out that there is one document in number two where they give a glowing review of Trooper Lopez, something about some mission he had to go on and with another colleague and almost very little time to prepare. So he got a letter of praise. I said, I noticed they didn't redact that one. I said, but that's the only such letter in his career that apparently exists in his file, since apparently they're more than happy to give me letters of praise. And then, of course, we have 137 pages fully redacted. So that was the second set. And so the third set should never have been even submitted to this court. It was not what I was looking for. So no need to bother with looking at that one. And it should have been clear that that's not what I was looking for. Same thing for number four. I'll briefly remind y'all those were the letter of reprimand and the letter of counseling warning that was dated April the 12th, well after the March 24th letter from Ms. Holland. I said, so Your Honor, that takes us to 5 and 6, which are the critical documents that I have been looking for from the outset of this litigation. And those are the two letters of counseling warning that have been issued to Mr. Trooper Lopez prior to March 24th. And I said that the bottom line here, Your Honor, is that these letters of counseling/warning, the evidence is overwhelming that they have been used to conceal problematic and, in fact, illegal activity by troopers at the troop level. And I provided the specific example of Dakota DeMoss. It was all in my reply to the amicus brief. for those who may have chosen to look at it in our last feature. And I said, now here they're being called out on May the 23rd, 2019 for the Antonio Harris arrest. I said, now that's 13 days after this same trooper, Dakota DeMoss, was involved in the beating of Ronald Green, resulting in Ronald Green's death. I said, and 13 days later, he's being called out to meet with 4 of his colleagues, and while en route there, well, now that was another beating case. It's now another situation where we've been sued, we the taxpayers, over what happened in that incident. And so I said the only assessment that Trooper DeMoss's supervisor had of him is he gave him, guess this now, listen closely, a letter of counseling / warning that he was doing what? Playing his FM radio too loud while in pursuit, and his explanation was, well, I was flipping channels looking for the, quote, right song, unquote. And I said, Your Honor, I want to stress that again, and I repeated it, because I said, I don't know how better you can illustrate the abuses that are taking place through these letters of counseling warning. And, I said, I intend to, if I'm successful here, quite likely pursue more, and I certainly do. This is a test case, so to speak. And so, by the way, at the point that I had announced that, and he granted my oral leave, my motion for leave to argue the, God, I tell you what, friend of the court, I'm just going to call it that, amicus brief, the friend of the court filing. So he asked if there was anyone present to represent the State Police Commission. Now, I had not seen Miss Feeney walk in, was unaware she was there, but the next thing I know, it's about, Your Honor, yes. So he says, enter the well. So here comes Miss Feeney. She keeps her remarks extremely brief. Basically about 2 minutes, maybe 2.5, and she said, Your Honor, we felt that it would be appropriate for there to be some background. And by the way, Greg largely deferred, Mr. Fahrenholt largely deferred to Miss Feeney because of the obvious fact that she would know all about these letters of counseling, letters of reprimand, since she is the attorney for the Louisiana State Police Commission. Now, she is an outside contract attorney working for Taylor Porter. Those of you who have watched the blog know you will have seen her numerous times on our videos. And so she said, just by way of a background, this commission was created in 1991 by way of a constitutional amendment, and its rulings do have the effect of law. And she said that Rule 12.9 of the Louisiana State Police Commission specifically excludes letters of counseling / warning from release to the public. And I wanted to do a short rebuttal, and my cataract surgery, my vision is so much better in my left eye now, but I can't see behind that glass, and I did not realize that Judge Johnson had signaled me to hold off, and I was starting to say a few things, and he had to, whoa, hold on, Mr. Burns. So, and I apologize. I said I did not realize that. So he starts to ask Miss Feeney a few questions. I'm really glad he did. I'm glad he had some questions to ask her. And so he said, okay, Miss Feeney, now it's obvious that we have different categories of letters. We have these letters of counseling that, as I appreciate what you just said, they're not considered discipline. Yes, sir, that's correct. And he said, but they are reviewed on up the command to the colonel. Boy, you could almost hear a pin drop. And I said, I said to myself, time to answer, Miss Feeney. And she said, well, no, that's maintained at the troop line. I'm stuttering because, he hit the nail on the head. Of course, I had also put it in my arguments, my oral arguments, which clearly he listened to. And he said, so these things are then reviewed on up to command? And she said, well, no, they're maintained at the troop level because they're not disciplined. He said, And so it then went into the distinguishment. We talked. He made sure he understood, and he asked that pertinent question: was it reviewed on up by the colonel? And she had to answer no, that it was at the troop level. He said, well, now on a letter of reprimand. And she said, well, now that's very different. That is formal discipline. And so she said that will be seen all the way up to the colonel level, who has to sign off on it because it is formal discipline. So he definitely got the distinction between the letters of counseling and letters of reprimand. I think LSP, in my opinion, was interchangeably wanting to bamboozle not just Mr. Farenholt, but I think the court too. And because I'm going to all these meetings, there was no way to bamboozle me, and I don't know why they thought they could pull that off. But, you know, I'm not there. I'm not in their camp. So Mr. Farenholt then said, well, you know, I don't understand why my client, namely, well, Mr. Trooper Lopez, is being lumped into the same category with those of the Ronald Green matter. And that's not what I was doing. And I know he knows what I was doing, but I think he had noticed the damning nature of what can be in these letters of counseling / warning. What I was doing was demonstrating how they can be abused. And now I'm in the dark, okay? He's going to know what it says. I don't know what it says, so I'm having to somewhat fire bullets with no light in the room, okay? He's got an advantage over me because he now knows what these things say. And so, but I said, Your Honor, I'm very appreciative of Miss Feeney having basically hit the nail on the head. She answered your question truthfully. Therein lies the whole problem. It's buried at the troop level, and I have been told by a number of troopers that they are abused if you're in the clique, cause you basically not to be disciplined. Whereas if you're not in the clique or not in the frat or whatever you want to phrase it, that you're going to face very different consequences. And so I really didn't make a big secret of the fact that I don't intend to stop here. And I've said that previously on other videos, but you got to start somewhere. And I had already done a ton of work with regard to Trooper Lopez. So when I found out he had to, I said, this will be a great test case. So I did also emphasize that Ms. Feeney is correct. The LSPC was formed by way of a constitutional amendment in 1991. And I said, and circumstances were very different back then. I said, back then you would be very hard-pressed to find 5 people out of 100 who would have anything negative to say about LSP, and I certainly would not have been in that camp. I had absolutely tremendous respect for Louisiana State Police, as I think not all, but the vast majority of Louisiana citizenry did. This is a very well-regarded entity. And I said, that is not the case. Now, we're 31 years later, and this entity doesn't even remotely, not even remotely, resemble the agency that was there in 91 when voters approved this. And I did point out that Senator Fields had introduced a bill to abolish the Louisiana State Police Commission, and he did. It's either 233 or 263, I don't remember the number. It doesn't matter, because for whatever reason he chose to withdraw it, and I said that was very disappointing to me. But at any rate, I said she is correct about that. But, Your Honor, here's the bottom line. When we voted for that, we never would have done so if we thought it meant, oh, well, when I pull that lever to create the LSPC, I'm giving away my own constitutional rights, because these folks aren't doing anything to provide any protection to the public. I mean, nothing. And by sticking out their chests and saying that we've declared these letters of counseling warning to be off limits to the public, they are aiding and abetting criminalistic activity. There's no simpler way to say it. It would be one thing if they were ignorant, okay, but they're not. They have been made aware of it, and yet with everything that's been exposed about the abuse of these letters, okay, and with the Justice Department having just convened to make a big press conference that, hey, we're launching a pattern and practice investigation, the first statewide, and I pointed all this out to Judge Johnson, first such one in 20 years, the first statewide agency in 20 years. Well, if the letters of counseling warning are working so great, why was there a need to do that? Okay? The reality, and the embarrassment to the trooper. Oh, well, boy, we're paying one more whale of a price to keep the trooper from being embarrassed. I mean, we are paying an enormous price, and I said something further, and I meant it. I believe the LSPC has made a grave error in now going public and making it on the record. Now, even with everything that is out there, known now, they are still going on record saying we oppose the release of these to the public, knowing the degree to which they've been abused, okay? I believe that makes them civilly liable. Obviously, LSP is liable for incidents that occur of some of the things we've seen lately. It's just a matter of how much the check's going to be. But I believe that makes the State Police Commission, because you are aiding and abetting. And if it can be substantiated that a trooper that received these counseling and warnings when a more severe measure was required, and you blocked the ability for the public to learn this, then you fed into the beast that attacked and perhaps killed someone. So I made it clear that I believe they are now civilly liable. If I'm going to be blunt with you, if I had my way, they would be individually liable. Well, talk about that would wake some folk up, wouldn't it? Wouldn't all of a sudden be, my ego, I'm on the Louisiana State Police Commission. I was appointed by the governor. You know, and it's largely an ego trip. Make no mistake. And that's why the amicus brief was filed. They're going to make up this, we got to protect the trooper. No, they don't want their toes being stepped on, okay? They don't want anybody looking at, there's an infringement of their power, okay? And look, the bottom line is, if the LSTA, Louisiana State Troopers Association, or the Louisiana Sheriff's Association, if they say this better not happen, well, they're gonna hop to it, okay? That's the way it's going to work. And if you don't believe that, we're only, I don't know, what is this? It'll soon be July, so August, September, October, November. November the 3rd, there'll be a trial in Judge Don Johnson's courtroom, wherein the LSTA has sued the LSPC, saying you better not block our ability to contribute to a politician if we so desire. We got to do that, all right? Who do you think you are? Now, that's one time the LSPC stepped a little bit out of line, and the LST laid it long. We don't like it. And they even dragged Jason Hanneman in to the litigation. Now, I've already marked the date on my calendar. It's November the 3rd. I think the pre-trial order is due something like October 16th. Bear in mind, that's a first setting, though, so it's entirely possible that'll be pushed back. I have looked at the LSP's proposed witnesses. Ought to be interesting, because they have alienated some of those witnesses. Let me tell you right now, they have alienated them. Nevertheless, I'm sure they will do their duty and testify. But that's going to be an interesting trial, and I will plan to be there gavel to gavel, assuming it transpires. So how did things end? Judge Johnson said, I want each party to draft a final judgment stating what you want, and this court will, he gave us until midnight today. That's the reason I made no broadcast or made no feature yesterday. He gave us until midnight today. I can now report that both my version of the final judgment has been submitted and LSP's version of the final judgment has been submitted. We're going to give you the links for them. Judge Johnson indicated that he will make his decision by Friday. So everybody can hang loose. If I lose this case, I lose this case. It's certainly not the end of the world. I do have other plans if I lose this case. I gave it my best shot. I did an enormous amount of work, especially this past weekend. I'm tired, and as a result, look, I want to let everybody know, if you think I've forgotten about the cheating scandal, I have not. But I got to have a couple of days to relax up. Now, I had started some preliminary work on it, but I need a few days break. So I had said late this week, it's going to be at least middle of next week now. I mean, I want to thank, I have spent at least 10 hours speaking with folk extremely knowledgeable of what happened at that cheating scandal. And I'm very thankful. Let me put it that way. And I don't believe it's going to disappoint. I try not to ever overhype anything. I am going to have to put it into multiple parts. And I'm going to let you know now, and this forces me to follow through. I sent Jason Hanneman an email saying, I really believe you folks, the State Police Commission, need to send Colonel Davis a letter instructing him to issue an order prohibiting the destruction of any training academy records until further notice. Well, I'm not going to put all my eggs in the basket of the State Police Commission. I will have my own certified letter out tomorrow, out in the mail, certified to Colonel Davis, stating, I think you need to issue this order. The decision's up to him. I know what I would do, but that's his call. All right, folks, obviously Friday we'll know what, well, a judge doesn't have to adhere to the date that he gave, okay? But he's indicated to us that he's making his decision on Friday. If that holds up, we've only got 3 days to find out how this went. Now, I did forget to emphasize one point. In my judgment, okay, Judge Johnson specifically stated that the final part of the judgment that I draft had to contain the statement that this order is stayed pending review by the First Circuit Court of Appeals. And I certainly did adhere to that. So while we whomever you want to, I consider myself the people, okay? And not that we are adversary to troopers. I hope the day comes when we can be back like 1991 and have tremendous admiration for our Louisiana State Police and state troopers. I'm just telling you, it ain't today. It's far from it today. I pray the day comes, but it's not today. To use a little bad grammar, it ain't today. So we will likely find out which direction Judge Johnson goes in. I did tell him I'm jealous of him. I said, Your Honor, you get a guaranteed look at these letters of counseling / warning. I said, I may never get to see them. I said, but I want to emphasize one thing. I said, I had to do a tremendous amount of work to get those letters in front of you. And I did. And so I said, if you make a basketball analogy, you're going to score the basket. But I get credit for an assist. And I'm happy to have gotten credit for that assist. But there's no guarantee I'm ever going to see these records. And I know if state police has its way, not only will I not see them, they didn't want, and I don't think I feel certain they did not want the judge seeing them, okay? You got to wonder who's behind this stiff opposition. I can tell you who's behind. You know who's behind. The first letter might start with an L. Second letter might start with an S. TA? You reckon? I don't know. You reckon? Who knows? Take it to the bank. That's who's so staunchly opposed. We'll see how Judge Johnson rules, and we'll see how that trial goes in 3 months, where they're suing the State Police Commission. I think it's a pretty sad state of affairs that we have in state police right now, and quite frankly, I see scant evidence based on things that have transpired in the last few months of any significant improvement anytime soon. But I'm always an eternal optimist, so I'm believing that God's in control and that one day we will see the honor and the glory of state police restored. I just don't know if it's going to be in my lifetime. thank you once again. We will certainly let you know how things unfold. The cheating scandal is my next major project that will be coming out to you, and I think you're gonna really find it to be an eye opener. Thank you so much. Thank you for your dedication, and I will be getting me a good night's sleep tonight. Thank you once again.